Good afternoon. This is Gloria Nelson with TUG, and it's my pleasure to welcome you to today's TUG Connects 365 webinar. As you settle in and get ready for the start of today's webinar, let me give you a brief introduction for TUG, the user group.org, for both our current members and those of you who represent organizations that have not yet joined our online community of Infor distribution software users. We've all heard the phrase, knowledge is power, and I can say with confidence that after today's presentation, you'll be waking up tomorrow with a lot more of both. But today is only one presentation. TUG webinars, online forums, and member events facilitate the timely exchange of ideas and information to help you work smarter and with more confidence, and that is a powerful combination. If you're currently a member, it pays to get more involved. If you're not, please visit our website to discover why 2,300 heads are better than one to help you be the best at what you do. And now it's my pleasure to introduce to you this afternoon Nathan Steed, partner, and Kelly Hollingsworth, associate with Warner Norcross and Judge Law Firm. So Nate, give me just a moment here. I'm going to transfer the use of the screen over to you, and we'll let you know when I have you in my sight lines. And I see everybody facially here, so if you want to go ahead and share your screen. We're just waiting for it to populate. Oh, hold on a second here. All righty. Kelly, you should see that little box populate, and we're looking at your screen. Go ahead and take it away, and I'll see you at Q&A time, folks.
Thank you, Gloria, and good afternoon or good morning, as the case may be, to everybody joining us. We're happy to have you with us, and our goal is to make you superhuman strength today if knowledge is power. So quick intro on both of us. I'm Nate Steed. I specialize my practice in software licensing, including SaaS agreements and everything related to software acquisitions, including audits and all of that stuff, terms of use, and software developers and data privacy.
And I'm Kelly Hollingsworth. I also specialize in technology transactions, software, and data privacy and security.
So today we want to go through a few different topics related to software licensing agreements to really help you understand from a non-lawyer perspective some of the things that your attorneys are going to be thinking about as they work with you on contracts. Our view has been that if the business folks and the lawyers understand each other a little bit better in the process, it makes for a smoother overall contracting process and ultimately a better product at the end. One thing that we hear a lot of when we're dealing with SaaS agreements is this statement you might have heard from some of your vendors before, that click-through agreements are non-negotiable, that there's this notion that SaaS terms are so turnkey, both the product and the terms, that nobody negotiates these things, that you can just plug and play and you're off to the races, don't need to worry about them, everybody accepts these things. In fact, there's a standard line that you've probably seen some variation on this, that everybody operates under the same terms and that they're industry standard. Well, there isn't really an industry standard when it comes to SaaS terms, and you should be wary if you have a vendor who is telling you this. At a minimum, we would recommend that when confronted with non-negotiable SaaS terms, that you should add a signature block to the agreement, print it out and sign it, and at least store that in your contract management system so that you have some record of what the actual terms of the agreement were if there is a dispute later on. The concern with clicking through certain terms is that if there is an issue and you need to consult what those terms were, sometimes it's very difficult to find what the terms were that you agreed to at a certain point in time. The funny line I see in this quote here that we often hear is that enterprise software, it's not enterprise software, it's SaaS, which really, what does that even mean? That SaaS can't be enterprise software? So again, be wary when vendors start giving you some line on whether these things are negotiable or not, because depending on the spend and the leverage that exists, a lot of this stuff is negotiable. So some of the things we're going to look at, we have kind of a list here, a top 9, if you will, of different items. The one caution we want to provide before we dive in, though, is that the risk of looking at these in silos is to get hyper-focused on each individual item. Usually, though, when you're negotiating an agreement, you can make up in one area what you may give up in another area. So you really need to think about contract terms holistically for the purposes of this, but for organizational reasons, it makes sense to look at these through different subject matter. Really, like we said, we want lawyers and the business people to understand each other to make it better at the end. And one other thing I want to mention is that we are providing some specific sample language that we have seen from vendors. These are provisions that we've seen and language we've seen in specific agreements. So it may seem crazy, some of these terms that we're sharing with you, but rest assured we have actually seen these as standard terms in a licensing agreement. And we'll talk about how you may have gotten in trouble if you agreed to the specific terms that we might be sharing here.
So the first thing we're going to talk about that's probably most important in your mind is pricing. And this is very important because a lot of times, lots and lots of time is spent negotiating pricing, making sure everything's good. You might be signing up for a 5-year term, locking in what you think is really favorable pricing. But if you look at the terms, a lot of times you'll see something like this from the vendor, which basically says that the vendor can modify fees at the end of the current term upon 30 days prior notice to you. In fact, we actually see a lot worse than this, and they can change the pricing terms at any time during the agreement. So this one is a little bit more favorable. But the problem here is, one, how do you know what that price increase is going to be? It could be 25%, it could be 125% of your current pricing. There could be a scenario where you're not actually getting notice because they said they're going to email it to you, and what is that email address? And finally, if the window for where they're bumping up that pricing has already surpassed your window for letting them know you want out of the agreement, you're kind of stuck with that pricing. So when you're looking at pricing, you're going to want to make sure that we've addressed these 4 items, which is limiting the number and timing of the increase. So maybe it's only at the end of the term, and they'll let you know 90 days in advance. Maybe it's for the first 3 years. If you've got auto renew, the first 3 years is locked in. From there, though, you're also going to want to make sure you've capped what that increase is. Typically, we see between 3 and 5%. Sometimes it's tied to CPI. But you can get creative there, but make sure you're locking it in for budgeting purposes. And we hear sometimes like, well, we shouldn't agree to any sort of price increase because then, they can't come back to us. And typically then you'll see the vendor say, well, we just can't offer this product anymore at this pricing. So if you've got some wiggle room there, it's quite helpful. And the advance notice we talked about, making sure that that lines up and gives you enough time to terminate the agreement if you don't agree. One thing that we hear a lot from vendors is, well, we have to agree to increase pricing every year to reflect inflation and our services improve. And, an argument that's never successful, but that you can throw out there is, well, shouldn't it become less expensive if it's the exact same product for 10 years? Like, what are you adding that's justifying an increase in cost? Now, all of this is a lot more important the more critical this is or the more unique the solution is. If you can easily jump ship and go somewhere else, you've got a lot more leverage to say, bring that pricing down or I'm going to your competitor. Where they know that this is unique, this is where you really are going to want to fight to get it in the contract because they know when you say you're walking, you're probably lying and they'll call your bluff. So here's some good compromise language that we like to see. And we'll make sure you guys get the slides afterwards and feel free to use this. But this says, you can increase the price for the services no more than once annually upon 60 days notice here. That 60 days assumes that you have a 30-day notice window for termination. And then, you got to make sure that the increase doesn't exceed X% for CPI over the previous 12 months. And that increase won't become effective until the next billing cycle. Here too, though, watch, because it's an annual increase in this language. If you've got a 3-year term, you wouldn't want to agree to this because that would let them increase the price during your term. So other modifications that we see vendors try to sneak into agreements, besides price changes, are changes to services and then also changes to the term of the agreement themselves. The latter of which we'll see all the time because that's why they gave you the link in the first place, and that's why we fought so hard to actually get an agreement that we're negotiating. And in that case, while we're on the subject, This is language that should be in any contract that you have actually spent time negotiating. And it says that you can't modify the agreement without both of you signing off on this. You've spent the time, you've gotten the terms you like, or at least are more comfortable with. They shouldn't be able to unilaterally go in and change them. There are some exceptions to that. You know, they might say, well, we need to be flexible if there's a change in law or something like that. And certainly you can build that in. You can also build in, you know, something on the other end that says, fine, you can change them, but you have to give us 60 days notice before they go into effect. And if we don't like that, we can walk. So there's some ways to get around that. But modification to the services is probably one that I think gets ignored, mostly because the vendor will give you these lines here, right? It's really beneficial to all of our customers to let us add new functionality. That's why you're doing SaaS, is to keep adding things. And, you know, this guarantees that you're getting the best out there. And I wouldn't disagree with that. I mean, that is one of the benefits of SaaS. However, we want to make sure that things that we've gotten comfortable with or that we've built, we've relied on using certain functionality doesn't go away. And, you know, if it is going to go away, we had enough time to vet somebody else to get them in there. So here is some language that is pretty helpful in that regard. It basically says, yes, you can modify the service. That's fine. Anything's permitted, but you do need to give us notice of that. And any change that you make isn't going to cause a material loss in functionality or degradation of the services. That loss of functionality is very important because it might be something that's very important to you, but no one else is really using it. And so the vendor would say, well, no one else is really using it, so we're sunsetting it and going to something else. So making sure that you've locked in the functionality that you're using to give you at least the right to terminate and a good amount of notice to deal with those changes is very important. And Nate, we're going to turn it over to you for service levels.
All right. So SLAs, Kelly and I love SLAs so much, which is probably why we're doing what we're doing. We could probably spend 30 minutes just on SLAs alone. We won't though. But there are a few topics related to SLAs that we want to touch on. So here's a good example of language that may look good at first blush, but once you dig into it a little bit more, it's not as good as you may think. So look at the first line. Service will be available 100% of the time. And when you're reading that, you may think, wow, this is amazing. It's going to be up all the time. Then you get into the exclusions, which some make sense, excluding scheduled or emergency maintenance. Okay. And then we see what service downtime exists and how it's measured. So when you can't transmit or receive data from the service, that's considered downtime. But it also is dependent on you opening a trouble ticket with the vendor. So now you have to know it's not working, and you need to take some steps to proactively notify the vendor for it to count as downtime. Further, if you keep on reading, that you'll see you'll get a credit once for every full hour of downtime, your credit is 2%. So what started as a 100% uptime guarantee, now nothing happens until after an hour of downtime, and now you're at about 99.8 and change of uptime commitment before the remedies kick in. And really, if you don't have a remedy, do you even have an SLA? That's kind of a philosophical question. If the only thing you have is a guarantee of uptime, what is your remedy if they don't hit that? It's probably termination. And is that really the remedy that you want to enforce? So the caution here is don't get affected by kind of the shiny things when you look at an SLA. Here we have the 2% refund of the monthly fee, but then it's capped at 50%. So again, if it's down for the entire month, the most you're getting back in that month is 50% credit for future months. And again, if you have a product that's not working as a credit, really that helpful. So let's look at some general thoughts related to SLAs. The one thing you want to watch out for is the standard SLA, because it's going to be written to the vendor's favor. And as you're reading it, take a really suspicious eye to the language and be very skeptical in what you're looking at and try to see in what way are we going to have problems if we have to enforce this SLA. You may have certain things that you need to measure beyond just simple up and down time. So response times may be important, or service level commitments related to specific services. So call time or response time as far as escalation goes. Again, make sure that there is some sort of uptime commitment in the agreement and that uptime commitment works for your business. You also want to define clearly what constitutes downtime. Sure, scheduled downtime makes sense, and we all understand that a system needs to go down sometimes for upgrades or just maintenance. But what are the parameters around what that scheduled maintenance looks like? And we'll look at that, some sample language in just a second. Who has the responsibility to monitor uptime, and are you, as the customer, able to look at that uptime and provide your own report back to the company and say, hey, we don't think you met the obligation in this specific month? Or is the vendor going to provide you monthly reports around what they think the uptime was? Again, you want to understand what your remedies are, and related to that is a termination right for chronic or severe downtime, and we'll look at some sample language in this next slide as well. So related to scheduled downtime specifically, some things you want to think about are whether you want to put parameters around the extent of that downtime. So here the sample language puts a box around 4 hours of scheduled downtime in a month. If it's beyond that, then it no longer counts as scheduled downtime, and you are then potentially going to be able to get credits for that downtime. Also related is how much notice do you get before that scheduled downtime. Here, as the sample language shows, is 72 hours advance written notice. You want to make sure that if there is going to be a time of scheduled downtime during a business critical time, that you have provisions made for replacing or some substitute product that you can use during that downtime. Here, note that the language requires it to be during non-business hours, as long as they're using their best efforts to do that. So again, as long as scheduled downtime works within your business, you have some flexibility in here to understand what those parameters are and kind of enforce those on the vendor. The second example here is for chronic downtime or 1 month of really bad downtime. The problem we sometimes see with customers is that the credits are a sole and exclusive remedy for failure to hit the uptime commitment. And if you were getting a credit in month 1, and then in month 2, and then in month 3, and the credits are as they're outlined in the agreement, but you're still not happy with the contract, your only remedy is those credits. In other words, you can't enforce a termination right in those situations. And you or your leadership may at some point say, I'm sick of dealing with these guys. The system works kind of okay, but not nearly as good as they said it was going to, and these credits at this point are not sufficient. We want to get out of this. Again, oftentimes there's sole and exclusive remedies for the downtime as credits. So you want to build in a termination right. And here the sample language we have is if it doesn't hit that uptime commitment in 2 consecutive months or 3 months in any 12-month period, then you can terminate. Similarly, if it's really bad in 1 month, and here the sample language says 90%, you can also terminate. You're never going to get rich off of your credits. You're not going to make a lot of money. You're just going to be somewhat made whole, hopefully. So the credit mechanism and termination right really functions more as a stick in the carrot and stick analogy to get the vendor to fix the problem for you because they're scared of losing you as a customer.
I'm going to pause there for questions if anybody has them.
We don't have anything that's populated just yet, which means that you're really speaking solidly into the content. So I'll keep a watchful eye for you. Go ahead and continue, folks.
I will say one question we sometimes get on this topic is, what if we have multiple things that we're trying to measure as far as an SLA goes? And here again, you can get really creative with how you do it. I've seen clients essentially say there's a bucket of money that we can draw from for our SLAs. So that is, let's say 50% of the annual spend is available to us as credits, and then you apportion out a percentage for the different SLAs that you're measuring out of that bucket. And so you can say, for example, if it doesn't hit the uptime, we can draw up to 50% of that bucket for the SLA. Or if there are call responses that we're looking for, or response times measured in milliseconds, or different things that you're measuring within the agreement, you can use those to draw out of that bucket, again, if you have multiple things that you want to measure.
Yeah, and another thing that we see a lot now, especially more than ever, is vendors saying, look, these are our standard SLAs for everyone. We do not agree to change them. And that may or may not be the case. I'm sure if there was a lot of money on the table, they'd be willing to change them. But what you really want to do in that case is 2 things. One, make sure that you're asking for historical uptime and talk to others and see if they've had any problems in the past, so you're at least alerted to it. And 2, to Nate's point, if there is sole and exclusive language in the SLAs, let's build into the contract some ways to get around that, or at least, hey, if we're not happy here, we can terminate.
And I will say, kind of related to this and the broader question is hyperlinked documents, and we see SLAs more and more hyperlinked within the document as opposed to attached. So you're going to want to attach those as an exhibit typically.
All right, I'll cut us off because, like we said, we could talk about this forever.
Yeah, we could keep going.
But we'll move into termination and suspension. So termination and suspension, the vendors often like to tie these together, but we would argue that they should actually be very separate things. So suspension is where the services are shut down, but your whole agreement still goes on. And in most cases, you're still paying for it. But also your data's still there, the platform's still working, everything's good. They've just locked out you or one of your users. Termination, though, is where the whole agreement's gone. And this language that we have up on the screen is very common language where the vendor will say, look, we can suspend or terminate you for all of these different reasons. Basically, anything under the sun. If it's raining outside, they could probably cut you off. And what you will hear every single time when you raise this is, oh, but we would never do that. We would work with you first and make sure that you would know if we're going to cut you off. But that has not always been the case, and a vendor can use this right. So and then they'll say too, like this is to your interest, right? Like if something is putting the security of our systems at risk, you are going to want us to shut that down so it doesn't affect your system. And that's probably accurate, but that again would be a suspension right, not a termination right. So we want to make sure that we've separated the two, and we just are talking about suspension in these cases where the vendor's saying, look, we need the right to shut off your services. If things are rising to the level of needing to terminate, we would refer that to the whole separate section in the agreement, because there will be one about when things can be terminated. So we want to make sure that we're getting notice of suspension to the extent that that is possible. In the situation we talked about with security, you're probably not going to want notice before they shut it down. You're going to want them to deal with the issue first. We're going to want a good faith requirement. So they're not just shutting you off because they feel like it or because they think you haven't paid your bills or they just don't like you. There's actually a reason behind what they're doing. And then limited scope and limited duration, meaning they're only going to suspend the part of the service they need or the users that they need to suspend for whatever's giving rise to the issue. And they're only doing it for as long as it takes to address the issue. So here's some nice sample language. You'll see here that we say they're only able to suspend your services or your authorized users' access to the service in the event they, in good faith, determine these several things. One, there's that security incident, we've talked about that, and also, if we breach the agreement. But we've said they're going to provide us notice in advance of the suspension unless it's not possible, and then they're going to use efforts to tell us as soon as possible after they've shut us off. And then there's that language at the end, limited in both scope and duration. We do get a lot of questions here like, well, what does that actually mean? And there's not a good answer to that. It just gives us some teeth to call them out and say, hey, you're breaching this agreement. You shut us down for 3 months for a little teeny issue. Turn it back on or you're in breach of contract.
All right, touch briefly here on disaster recovery and data backup components of this. So notice this is sample language and who is responsible for conducting the data backup piece here. You are. So again, this is a section that's not necessarily bad, but the key is to understanding who is responsible for what. And if you are expecting to be on the hook for data backup, then this language isn't that bad. You can live with this, but the key again is to understand. So who's backing up, how often are the backups occurring, and then where are those backups being stored? The question is all of this adequate? Sometimes it may be, sometimes it may not be, and you need to understand what the business needs are related to this. Connected to this is data recovery. So does the service provider have some sort of plan, and is it adequate? How will you know that? You're going to have to ask them and see it. It wouldn't be beyond the pale to include that as an exhibit to the agreement as well. They're going to want some flexibility to modify it, and that's okay as long as it doesn't get any worse than when you review it, and you can build that language into the agreement too. Related to this is who is able to declare disaster. Is that something that you are able to declare or the vendor is able to declare? The other piece you want to really think about here is how this interfaces with the force majeure provision or the acts of God provision, and that's usually toward the end of the agreement in the general or the miscellaneous section where there's this list of terribles that says neither side is responsible for performing under this agreement for reasons outside of their control, including flood, earthquake, coronavirus, sinkholes, etc. So those situations shouldn't relieve them from their data backup and disaster recovery provision, because that's the whole point in having disaster recovery is for disaster. So understand that you want to make sure that the force majeure provision doesn't eliminate the requirement to have disaster recovery language built into the agreement as well. Understand too, if the vendor is going to have access to data that you do not have access to. If they are creating data, if they are getting data from you, putting it in their black box and then storing it, you're going to want to make sure that that disaster recovery and data backup language is stronger to protect things if you're not conducting the backup on yourself. So really the compromise position here isn't necessarily language, but just making sure that the responsibilities are clear, everybody understands who's doing what and when, and that it is in the contract, that you memorialize that through the terms of the agreement, and that it does meet whatever operational or organizational needs that you have within your business.
And I will say that letting your lawyers know that you do not have backups of the data and that the SaaS provider is going to be the source of truth is very important, because in almost every agreement, they will, regardless of whether they're actually in charge of backing up their data, your data, the agreement will probably say they're not responsible for any loss of data. So we need to make sure that we're aware of that so we can help address that in the agreement.
As it comes to security, this is oftentimes one of the biggest issues in finalizing an agreement, because in the SaaS context, your vendor or your service provider has access to your data, and you want to make sure that that data is protected. So look at this model language, which again, at first blush, doesn't look too terrible, that the service provider is going to perform in accordance with their own security and privacy policies and will act promptly on any nonconformance, and that they have an annual audit conducted and that covers their operations. A couple things to look out for, though, here. Note that the service provider is responsible for complying with their own security obligations, as opposed to what your security needs may necessarily be. There's no right for you in this to see anything, and no obligation for them to actually remedy anything that is identified in the audit. One word of caution as well: if you are collecting consumer information, you're doing so pursuant to some sort of privacy policy and use policy potentially. If you are telling your consumers, we are collecting your data and using it for these purposes, and then providing it to a third party, you need to make sure that that third party is also complying with those same purposes for which you've disclosed use to your consumers. Here then, it would make sense for the service provider to comply with your policies and procedures related to the security of the data, not necessarily their own. And this is becoming more and more important with GDPR, CCPA, and the list is going to grow within the United States as far as consumer protection laws that apply to the collection and use of consumer data. So as you're working through this, there's some things to consider. You really need to understand the nature of the data being put in the cloud, and your attorney really needs to understand it as well. Some data may not be as sensitive as other data. I think we all understand that. If it's not a big deal, you can maybe get away with lesser protections or money liability around breach of that data. But if there are legal or industry-specific requirements like GDPR or HIPAA or PCI or NIST that you need to be concerned about, then you may want to think about embodying those in the agreement. Excuse me. So what happens in the event of a data breach or breach of security? This, again, is one of the most often negotiated, stridently negotiated sections in the agreement. The money attached to a data breach becomes a big issue here, and it is one that relates to leverage within the agreement and dollars spent within the agreement too. The vendor, from their perspective, is very concerned about the world of damages they're opening themselves up to. They don't want to be on the hook for lost reputation. They don't want to be on the hook for lost profits. From your side, you want to make sure that you get made whole for hard costs related to a data breach. These would be things like investigation and mitigation activities, notification both to potentially affected individuals or government entities, credit monitoring if you think that's appropriate for the nature of the data that is compromised. staffing a call center if that is appropriate, fines and penalties that the government may bring against you. All of these things are negotiated and really done in light of any sort of limits on liability or super caps that are related to it. But it all depends on the volume of the data and the type of data that is at risk, and really how many individuals are potentially affected by a data breach. You want to think about what triggers notification to you. So in other words, in the agreement, what does a data breach actually mean? Does that mean that access has been confirmed, that it's reasonably likely? We always say, or we try to negotiate that you should be notified of actual or reasonably suspected unauthorized access, use, and disclosure, and try to avoid the defined term like a breach in that situation, or define breach very broadly to mean that thing. The reason this matters is because you want a seat at the table if there is a potential security incident that needs to be analyzed for legal requirements, usually notice requirements on top of that. There is sometimes in state law some sort of reasonableness standard baked into the determination as to whether a breach has occurred. And just to give you an example of what's required in Michigan, you're not required to notify an individual if they have not or it's not likely to cause substantial loss or injury or result in identity theft. There's some squishy words in there, not likely and what does substantial mean. So if you have a vendor who's making that determination on their own as to what's likely or not or what's substantial or not, chances are they're going to side on, if it's close, on it not being a breach because they have a financial incentive to decide that way. Whereas you, where you have the legal obligation to notify, you may see things much differently. So again, you want a seat at the table for these security incidents so you can understand the risk profile that you are exposed to. Similarly, if you have a vendor who is experiencing significant amount of security incidents, but just so happens that the data wasn't compromised or notice is not required, you're going to want to know that too, because it may be a warning sign of a vendor who has a lax security posture, and you may need to make some decisions as to whether you want to stick with that vendor or not. So here's some compromise language that can maybe fill in this gap a little bit. Notice here we have a requirement for reasonable administrative, physical, and technical measures that are required of the vendor to secure their data. It calls out specific EU personal data or Australian personal data laws if that is required, and it just provides you a lot more protection in this area related to data security.
Pause here for questions.
We do have a question. What's the recommendation to modify an existing contract either on fees or terms?
Yeah, so fees or term, you could do it several ways. A lot of times what just happens from a practical standpoint is that gets negotiated at the order level between the business, and it never makes it all the way up to legal. But otherwise, we could do a formal amendment that just says, hey, see this provision where we talked about fees or term, delete it, and here's what we're agreeing to now.
Yeah, and I would say this, the key here, if you are in an agreement that is not good, is what can you offer the vendor to get them to the table to help you get more favorable terms. That may be extending the term of the agreement. That may mean making additional purchases at that time. And the other thing to think about also is sometimes what we've seen is you sign a contract with a vendor for a very small engagement or a very discrete type of data, and as the relationship grows, the data changes or the spend changes, and all of a sudden you realize a couple of years down the road that the terms you negotiated originally aren't that great for the amount of work that you're doing with that vendor. That provides a very good opportunity to get some sort of amendment in place also and say, hey, look, things have really changed since we started this relationship. You have very sensitive data of ours now, or a lot more data than ours now, and we need to reopen the negotiations as far as security or pricing goes.
So suffice it to say also then it would be a good idea to have either a clean contractual service agreement without additional things written in the margin, and either have a clean contract for that service agreement or a clean amendment to that contract, correct?
Yes.
Okay, thank you. That's the only question right now. Great job, guys. Keep going.
Okay, now we're gonna get into the real legal stuff, but bear with us. We're gonna try to make it as easy as possible. First, we're gonna talk about warranties. And spoiler alert here, if you see anything in all caps within an agreement, what it really means is, hey, your rights that you wouldn't normally think you've got are going to be taken away from you. Caps are bad, pay attention to them. Ironically, usually when you use all caps, it makes it very difficult to read. But here, when you get to the warranty section, it basically says, we're not giving you any warranties. None at all. It's provided as is without warranty. Not so great. Common areas where we like to see warranties that we have disagreement on are the service levels, which Nate talked about a little bit earlier, security obligations and what those are, and remedies for breach of warranty itself. So usually you'll see a warranty maybe that it's going to comply with the current documentation, which presents kind of its own problem if they can update that documentation and then say, look, now it complies. And often it doesn't go beyond that. So there's a few problems with warranties, but I will back us up for a second and talk about the importance of warranties to begin with. So warranties are important because if there's a breach of that warranty, then it's an automatic breach of the agreement, and you automatically get to go check what your remedies are. Is it termination? Is it getting money back? What is it? So when a vendor offers great warranties, you want to be sure that they don't have sole and exclusive language that says, okay, here's your warranty, and here is your only remedy that you could get. So we're looking at warranties at least to the service level agreement, and as Nate said, there might be appropriate sole and exclusive language there. Security, what are the security features you're going to provide? Do you warrant that you've at least used commercially reasonable efforts to prevent viruses, to keep your system safe, etc.? Operation in accordance with the specifications. And there you're going to want to look at what the documentation is, because that's usually what they rep to, but also make sure that if there's anything very important to you in those specs, you lock them in, either in an order or wherever it is, and then you reference that. And if they're going to be providing any professional services, you'll see this good and workmanlike fashion. That's just legalese for they're going to do a decent job. So sole and exclusive remedies are usually limited to, hey, we'll repair it and we'll get it working the way it's supposed to work. And sometimes if we can't, we'll let you terminate and get a refund. But that language at the end isn't always there. So when you strike that or you say, no, we don't agree to sole and exclusive language, the vendor will say, well, what do you think you want then? I mean, what else would be an appropriate remedy? Now, when we're talking about some of these things, SLAs like we mentioned, specifications, good and workmanlike fashion, those probably are okay. We would want them to fix it and make it work the way it's supposed to. For the SLAs, we want to get those credits and have the right to terminate for chronic failure. For specs, yeah, we want it working. We want this working the way we thought it was supposed to be working. We want to get the money into it. We want to have what we thought we were buying. And same with services. We want them to just perform it and make it work the way it was supposed to. So sole and exclusive might be fair there. But this is where your lawyers are going to ask you, hey, tell us what happens when something goes wrong. What goes down? What's not working? How are you made whole? And if you can say, yeah, we just want them to get in and fix it, then language to that effect would be good, as long as we can make sure they're going to get in there and fix it within a very quick time or whatever it is. Now, if we think about something like security, if they introduce a virus into your system, them fixing it and, that's not going to help your system and all of the damage that caused. So sole and exclusive remedy language there wouldn't necessarily be appropriate. So really just think through what those warranties are and make sure that the remedy makes sense. Because if not, in some cases, you might be better foregoing the warranty entirely if your remedy isn't going to make you whole. Ooh, indemnification.
All right, so we get it as far as warranties go, indemnification goes, limits on liability, which Kelly's going to touch on next. All these things in the contract are where your eyes start to roll back in your head and you just say, I'll just let the lawyers figure this stuff out. And we will help you figure it out, but it is, again, to my earlier point, a much better process and product if you help us understand what the risks are. To Kelly's earlier point that she just talked about, we need to know what's going to happen if things go wrong so that we can properly address it in the agreement. Indemnification, in its very simplest form, means that the service provider is liable for something instead of you if you get sued for this. So the very prototypical example, which we'll look at in language in just a second, is let's say Infor stole their software from somebody else and now you're using it. And now you get sued for using that. Under United States copyright law, because you're using it, you can be sued for that, even if it's stolen. And you can't say to that copyright holder, hey, we got it from Infor, this isn't our fault. That doesn't matter under US law. So there are some situations where it makes sense for the vendor to be on the hook and not you to get sued for something the vendor has done. So oftentimes we see this arise in a security breach context or notification cost, or if there's an issue around providing services. Think through whether it is appropriate for the vendor to come in and be on the hook for the damages here. Here's some sample language that you may see in agreement. This is related to intellectual property specifically, or IP claims. If you get sued by a third party because the person giving you the product didn't have appropriate rights, that person giving you the product should be the one on the hook. Now, this language is not bad in and of itself. It's just not enough for what you may want to address in your agreement. So some things to think about when you are negotiating indemnification are what sort of incidents will trigger that obligation. If they breach their requirements for data security and there's a data breach, they should be holding the bag for that. Again, the second bullet point is the IP infringement situation. The third one is property damage. If the vendor comes on site or they have service personnel on site that run over somebody in the parking lot and you get sued for that, the vendor or the service provider should be on the hook. So really think about, in the indemnification context, what could they do that you could get sued for? And if that happens, they should be the ones holding the bag for that liability. And that's where you address it, is within the indemnification section of the agreement.
Great. And finally, limits of liability. So you could have everything that we just talked about perfect in this contract, and it could be everything you want it to be. And then we could get to this section on limits of liability, and here you'd see that the vendor limited their liability to $100. So it really wouldn't help if they breached the agreement, because that's all you're going to get out of it. And in an ordinary contract, all of this would probably also be in all caps, so it would cue you into it. But there's two types of damages. I won't go into all the specifics, but the standard one you'll see is a carve out for things like indirect, consequential, special damages, blah, blah, blah. That will be in all caps. They'll usually make it mutual if they're trying to be nice. But it just means that the damages that wouldn't directly arise from this agreement, you paid us fees, this doesn't work, you get your fees back, that's direct damages. You paid us fees and there was a data breach, and now all your customers' information is out and you have to deal with that data breach, that would be indirect. So we want to make sure when we're talking about these two buckets, we don't just ignore the one and focus on the other, which is the second paragraph here that says, okay, we're not liable for all these types of damages. And then if we are liable for direct damages, we're only liable for this tiny amount. So, two schools of thought here. What we would, if you were writing an agreement from your perspective, the customer's perspective, you would just be silent on limits of liability. We wouldn't even talk about it. And that way, the court could decide if they're liable or not. And so what we would do is take all those things they're liable for and remove the caps that they've put on them. So instead of $100, it's just totally uncapped. There's two schools of thought there, depending on which side of the table you're on. From the customer's perspective, look, things like data breaches, things that could go wrong in the SaaS context are so hard to figure out what that dollar amount would be in some cases. All of a sudden our systems aren't working anymore, and what does that look like from a monetary perspective? We can't figure that out, so we're just going to leave it uncapped. But what the vendor will always tell you is, well, look, if we have uncapped damages for anybody at all, then we can't make anybody whole. And that's, probably true, but you don't want to be the one sucker who agreed to a cap on damages and everybody else has uncapped damages, and so they're never going to get together. Unfortunately here, the compromise tends to be a lot of times who has the leverage. But there are some things that you can do if you are the small player here to make sure you're a little bit more covered. So making sure that specific claims are uncapped. breaches of confidentiality is a great example, and that goes back to what I was talking about before with the two different buckets of damages. We want to make sure at the very least that certain damages associated with the breach of confidentiality, like your data breach notification requirements, would be considered direct damages and pulled into that second bucket of damages to make sure it's just not off the table entirely. Also, and this is where really the lawyers spend a lot of their time negotiating, is, okay, fine, you're not going to give us uncapped liability. Let's cap it at something that's more than the fees we've paid you under this agreement for that $100. So what does that look like? And that's where we will come back to you and say, okay, how many records are at issue? What happens if this goes wrong? How much money is on the table for you? And sometimes you say, look, it's really not that big of a deal. We don't care. We're fine with just capping it at what we've paid. But other times it's like, no, we're going to have all of our customer records, and they all live in California, so we've got all these other requirements. So we're looking at a few $1 million. That's something that your lawyers will want to know, and that's where we would play around to get where we needed to be. Also, can you mitigate the risk? If they're saying, look, we're not covering you for data breaches, can we make sure that personal data is excluded? And again, who has the leverage? That's really going to be, if you've got a lot of money on the table, you're going to get those higher caps. And unfortunately, that is the way it tends to be these days. And with that, final questions.
We do have a question that populated. How would you rate Infor standard contract compared to other ERP type contracts?
Well, that's a loaded one.
That is.
I'm trying to think how we can answer that.
Not the best, not the worst.
Yeah, I think that's a good way to put that.
I think there is room to negotiate in there, but you're starting off at a little bit better position than others that I've seen. And I think Infor tends to be responsive to reasonable requests.
I think they do a better job of starting, they listen and they start to build that into their base contract. So I think they get sick of us hitting them up every single time, and they do start to build some things in.
Right, right. And we know when it comes to negotiation, rather than defining and drawing a line in the sand, it's really important to make a reasonable request and allow that response time rather than having a kind of a gut reaction. Would you say that that's a positive way to approach it?
Yep, absolutely.
Yeah. And one thing we see a lot too on back to liability is the question of insurance and where does that role come in as far as the vendor's insurance goes. And it kind of can go both ways. If it's a really small company, I mean, you'd like to see they have insurance. If they're a bigger company, it might not be as important. But where we really caution is making sure that we don't just let the vendor say, yeah, we'll just indemnify you to whatever our insurance is going to cover, or we'll be liable up to that, our insurance coverage. That gets a little bit tedious and a little, it makes me nervous because if they have a data breach, for example, and they have a $2 million insurance policy, that goes to all their customers. So instead, what we like to do is say, no, you'll be liable up to $2 million, the amount of your insurance, not necessarily what your insurance will cover.
And I have a question just out of curiosity. I know that in other types of business, if you're dealing with a vendor and there's indemnification and promissory action, as you're talking about in these types of agreements, is it prudent to be asked to see the COI and be added as an additional insured on that coverage? Is that something that you do, or is it not necessary?
Yeah, for sure. See the COI, and I've yet to encounter any vendor who wouldn't share that information. To Kelly's point, we usually include that those insurance levels in the agreement, and then be named as an additional insured. There's some types of policies you can be. Typically, the commercial general liability policy is not a problem to be named as the additional insured. E&O, I think it may be a little bit more difficult to get there, but be named as an additional insured certainly is helpful. There may be a small fee involved in that. Sometimes it gets passed through, oftentimes it doesn't.
Interesting, very interesting. Those are the questions that have populated thus far. Is there anything else that you get as a frequently asked question with regard to the content that you've covered and shared with our members today?
I think probably our biggest is they say it's not negotiable. Like, can you just tell us that it's okay? and we'll tell you that everything's negotiable for the most part.
Right.
But yeah, it's the ones that aren't are few and far between, or just
Well,
they're really not worth it.
right. And one of the things to remember when executing any type of agreement is that everything is negotiable before you put your pen and ink to paper, and anything after that usually falls on deaf ears and is known as begging. Would that be a correct summation?
Yeah.
Well, that concludes our questions that we have populated this afternoon. Thank you, Kelly and Nate. As always, your expertise is so valuable to our membership and great media content in today's presentation. And as with most all of our webinars, this presentation will be available on our YouTube channel on the next business day because today is a Friday. So we'd like to thank all of you that have joined us today and invite those of you who are members of TUG to please continue this conversation on our Cloud Suite Distribution Group Forum Board. As you know, that's where so much information is exchanged and a lion's share of the value of our membership, not to mention our virtual as well as live content. And for those of you who are not yet members, if you look to the slide, you'll see our web address is theusergroup.org, and we invite you to join us. And Kelly and Nate, again, thank you, and everyone have a great weekend. As they say in Hollywood, that's a wrap, and we'll see you at the next TUG Connects 365 program. Bye now.